Hello, everybody. Welcome to training. Welcome to training. Welcome to training. I don't really care when you actually see this video, but it is right before Christmas. So I also want to say happy holidays and Merry Christmas to you and your family from me and mine. For training today, it's going to be pretty brief, just a lot of explanations and things like that. What we're going to talk about are the different addendum and or addenda, which is plural for addendum, which is singular, and we're going to talk about what they're used for, why you would use them, things like that. So I'm literally just going to go right down the list on the Trek website. We are not going to use zip forms for this. It's on the Trek website. Okay. So let's get into it. So when you get to the Trek website, you don't even need to log in. You don't even have to log in. Simply just go down right here where it says contracts. And it's going to give you three drop downs. You're either going to use the other forms, you're going to either use contract addenda or the contracts, which again, we are going to go over the contract addenda. But the first thing I want to show you is on the actual contract itself, what it has here. If you scroll down to paragraph 6, okay, right here, it has a little blank spot and it says required notices. Okay, let me highlight that for you. It says right here, required notices. This is going to be for like your PIDs, your MUDs, any kind of notice that you would have to give. That's what this space is for. And it gives you examples right above, right? So statutory tax districts, annexations, property located in certified utility districts, PID districts, propane gas systems, transfer fees. These are just other forms that you're going to find either on TR or the Trek website. And if you utilize any of them, they have made a space here for you in paragraph 612, 6E12 for you to just write out which one of these notices you're using. That is a different section than here in 22, where you're marking the addenda that you are adding to the contract. In 6E12, that is not for addenda. This is for addenda, and this is not for notices. 6E12 is for notices. So I just wanted to throw that out there first. Okay, so I'm going to get out of that. Just wanted to give you a quick little spill there. So we're going to, again, we're going to go right down this list of the addenda. Okay, all of these, we're just going to run through them pretty briefly. And I just want to make sure that we all understand what they're actually used for. Okay, so the very first one is going to be the addendum concerning the right to terminate due to a lender's appraisal. So this gives you three options, okay? Again, the addendum concerning the right to terminate due to a lender's appraisal. You do not use this document if your buyer is using a VA or an FHA loan. You do not use this document if your buyer is using a VA or FHA loan. This is going to literally be for any other loan. Okay, but more than likely conventional. All right, so you have three options. And let's just say for this example, the house price we're looking at is 400,000. Okay, so option one is a waiver. And what this is saying is that the buyer is going to waive the right to terminate due to a lender's appraisal. So what that means is I'm going to send this offer in with this marked, meaning if and when the appraisal comes in under 400,000, I'm telling you right now that I will not have the unrestricted right or the restricted right to terminate due to this lender appraisal, because on this addendum, I'm waiving that right. So if something goes wrong, and let's say the house is 400,000 and the appraisal comes in at 300,000 and your client doesn't have the 100,000, they cannot terminate due to the lender's appraisal because they waived that right here on the contract, on the addenda, okay, that you added to the contract. Now, on another note, if it's a partial waiver, that means we understand that we're offering that, or that the sales price is over market value, or that we are offering over market value. We understand that, but we're okay with meeting you in the middle. So although I'm buying the house at 400,000, if the appraisal at least comes in at 380,000, If it at least comes in, then if it comes in at 380 or more, then I will partially waive it. It doesn't have to come in at 400,000, but it at least has to come in at 380. I'm telling you now, with this partial waiver that I have, the other 20,000 that it will require to get to 400,000 sales price. But as long as it gets to 380,000, I'm fine with the appraisal coming in under 400. It just has to at least come in at 380. So that's a partial waiver. Now, if it comes in under 380, then now I get my rights back and I can go ahead and terminate due to the appraisal. Okay. Or I don't want that right to waive it at all. I'm sorry, or I want the right to waive it completely. Okay, so I'm going to mark this and I'm going to have within 5 days of receiving the appraisal, if that house does not come in at 400,000, which is what I plan on purchasing it for, then I want to be able to terminate due to the lender's appraisal. It's an additional right to terminate. Okay, so you got one that's completely waiving that right for the buyer. You got a second that's kind of partially waiving that right for the buyer. And then the third is I don't want it waived at all. I want the right to terminate. Okay. That's what this document is for. Why would you use this? If you're in a multiple offer situation and it's just more appealing to a seller that you're just going to waive the appraisal, that's really appealing. Your offer is probably going to get taken. Is that in the best interest of your buyer, though? Or that's the question that you have to ask. And the answer would be no, because your buyer could be coming out of pocket some good amount of money if they're waiving or partially waiving. But if they tell you, this is what I'm good with, and this is how I want you to write this offer. Remember the O in old car, which is your fiduciary duty. It stands for obedience. Send them the document and just have your own documentation that you did tell them what's what. Okay. All right. Next in line is the addendum regarding notice of obligation to pay a district assessment. So if there is some type of district assessment, whether it's a mud, PID, PUD, whatever that may be, this is the addendum containing the notice with the obligation to pay. There is also a form that you would put in 6E12 giving notice of that document. And then here is the addendum that you would put in paragraph 22 saying, here is the obligation document. Okay, so 6E12, you would put the notice. And then in paragraph 22 of your 1 to 4, you would put the obligation addendum. Okay, and that's all this is this is an obligation that I'm telling you as the buyer, you're going to have to pay your mud, PID, or PUD. Okay, that's all this means. Okay, moving right along. Addendum for a backup contract. This is pretty cool. And you can use this for totally in a number of different ways. If you are the listing agent and you have two offers that are just like neck and neck, and like literally the difference between the two offers is a net proceed or a gross proceed to your seller of maybe like $3,000. That's really the only difference. One person is offering 500,000, the other is offered 497. And when you get all the way down to closing costs, it's really a difference of those $3,000. Both offers are amazing, and you've received other offers that are nothing near these two costs, then what you would do is you would say, well, I want the one that's going to give my client the extra 3,000, right? The whole amount. But Mr. or Mrs. Buyer that's giving me the 497, I want you to be a backup offer, a backup contract. So I'm going to negotiate terms with both parties at the same time. The one that I go under contract for originally, the option period has started. The earnest money has been turned in. They're doing amendment stuff. They're doing inspections. So is the other side. Okay. They're going to go ahead and pay their option, and earnest money is going to be sitting at the title company. And there's going to be a date where if you don't terminate with the original person by this certain date, then now my contract just gets to be thrown away. Option and earnest money gets returned to that backup buyer, no problem. Or if you do terminate with the $500,000 buyer, the 497 contract automatically kicks in. The moment there's a termination, the new one kicks in. And now you don't have to go back through that list of other people who purchased something. You have to, or sent an offer for their purchase agreement. You don't have to worry about them because you already took a backup offer and negotiated terms. Okay, so this just saves time if you have anything going. Okay, so it's pretty good. Okay, so we have our addendum for backup and authorization for hydraulic testing. This is a form that addresses who pays for the hydraulic testing and damages or anything that can happen. If you're using hydraulic testing, this is something that the plumber is using, or it comes up on the inspection report because there's an issue with the plumbing or the piping underground or anything like that. So the buyer would have to pay for the plumber to conduct a hydraulic test and understand a hydrostatic test. I'm sorry, a hydrostatic test. And the issue with that is if there's any type of damage or anything like that, that buyer is assuming responsibility for that once they sign this document. Okay. And notice here on this document, it says that the seller authorized buyer at buyer's expense. It doesn't even give an option that there will be an expense to the seller at all. And then down here is the allocation of risk. Okay. All right. Next up is going to be addendum for coastal area. So this is going to be primarily for our agents that are on a coast. We don't have in the Dallas area, we don't have any coastal properties, so there's nothing that we have to worry about. But if you are one of the agents that work on any type of near of the coast, so my Houston agents, things like that, that's where this is going to come into play. So if there is a property that your client is purchasing or that you're selling, and it has a common boundary with a tide, or where there's water in the land meets or anything like that, you're on the coast, you have to give a notice to that, and make sure that everybody understands prior to transfer or guarantee of everything, that everybody understands that this property is next to a coast. Okay, so that's all this means. Okay. Okay, addendum for property in a propane gas system service area. So if there is a propane gas system service area anywhere near the property or on the property, you have to give that notice to that buyer, and the seller has to give that information out. That's all this says. You see how there's nothing that you can write here except the address, and there's a signing space for the sellers and buyers. This is just saying there is a propane gas system in the area or on the property itself, and you need to be aware of it. This is just saying that it's here. Okay. Okay. Addendum for property located seaward of the Ghost intercoastal waterway. Same type of thing for my Houston folks. If you're next to any type of seaward, that this is just disclosing a notice concerning the legal and economic risk of purchasing a coastal real property near a beach, right? Because of hurricanes, anything like that, you are assuming the risk here. You understand that you are purchasing a property, and these are the risk, these are some things that could happen. Okay, so that is just a disclosure, but it's an addendum that we have to give if you have a property by a coast. Okay. Okay, so now your HOA document, the mandatory membership in a property association document. Somebody has to pay for the resale certificate. Somebody has to pay for the transfer fees. Somebody has to pay for the deposits, for reserves, all of that stuff. This is just identifying who's doing what. So once you go under contract, if you want the seller to pay and deliver the subdivision information to the buyer, you would click number 1. If you want the buyer to pay it, it's number 2. If you've already given it to the buyer, and the buyer has received it and does not need an updated copy, that's number 3. Or if the buyer is not requiring the subdivision information at all, that would be number 4. Then you have the fees and deposits for the reserves. Typically, the buyer pays a certain amount up to a certain amount or whatever. For me, I typically put $50 here, and usually the ending fee is somewhere between $100 and $500, depending on what's going on with that HOA. But my buyer will pay up to 50 of that. The rest of it is the seller's cost. And then at the very bottom, we're talking about authorization, and the seller authorizes the association to release and provide the subdivision information, and the seller is going to pay for that at title. The title company is going to go ahead and take care of it, and the seller will pay for it at closing, is what I mean. Okay. Awesome. Moving right along. Okay, so the addendum for release a liability on assumed loan and or restoration of a seller's VA entitlement. Okay. So what this is saying is you are releasing the liabilities, the seller's liability on a loan that's going to be assumed, or you're restoring of the seller's entitlement for a VA loan. Why would you have to restore or release somebody? If you're going to assume a loan from a seller, that seller is releasing liability. If you're going to assume or if you're going to restore the VA benefits of a veteran, you need to restore that. So what that means is potentially this that means that a veteran has taken their property and they've allowed someone to assume their VA loan, and they went and moved somewhere else because the benefits were great. That was the only way they could sell the property. Well, now that person is getting ready to sell or whatever that may be. Well, now there needs to be a restoration of the seller's entitlement for that VA loan. Okay. Or the seller and buyer shall apply for the restoration of the seller's VA entitlement and shall furnish all information and documents required by the VA. Okay, so again, that's giving the VA person back their benefits. You're restoring that. Or again, if you're going to release a seller liability of a loan that was being assumed by somebody, you're releasing their liability because now you've assumed it. So it's no longer their problem, it's yours. Okay. Or you're the buyer or seller. Okay. So now we have the addendum for reservation of oil, gas, or other minerals. This is basically just saying that the seller is going to retain their oil, gas, and other mineral rights. The contract, as it's written, the 1-4 contract, as it's written, is written for the buyer to already take over those reservation rights. It's already written that way. It's nothing you have to click. It's nothing you have to look at. None of that. But if the seller is saying, "No, I want my rights. I want my minerals rights and all that good stuff," then that's when you would use this addendum. Okay. But again, the contract as it's written is for the buyer to obtain those rights automatically. But if the seller is going to sell a property but retain their rights, then you need this addendum for that. Okay. Mm-mm-mm-mm-mm. Okay, addendum for sale of other property by the buyer. This is a contingency. If you ever see on MLS, it says active contingent. That's what this is talking about. This is basically saying the buyer is putting a placeholder on your contract for your seller. I will buy your house as long as I can sell my house first, right? I can't do one without the other. So I'm going to buy your house and send you an offer contingent upon selling my house. And here are the details of me selling my house. That's all this is for. It's the sale of other property by the buyer. I need to sell my other property and then I can go ahead and buy your property. But I cannot buy your property if I don't sell my property. So by a certain date, if it has not sold, I have the right to terminate. Okay. Okay, for 1031 exchange, if a person, now remember, we are not accountants, okay? So you don't want to get too many details on this. You want to make sure that you're telling your buyer or your seller to consult with their accountant and things like that. But if you make over, I believe it's $250,000 per a sale per person on a home. So if I sell my house and I make 250,000 profit on the home, that's 1031 exchange money. I have to reinvest that money into a property, or I'm going to have a 1031 exchange tax put on me within the 2 year by the 2 year mark. Okay. So you want to make sure that when your client is using their 1031 exchange money to purchase a property, sell a property, whatever it may be, then that's what this is for. It's just a disclosure saying we're going to use some 1031 money. Okay. Okay. So the lead based paint. This one is one of the only documents that's an addendum that actually has a signature for the brokers or the broker associates, which would be you guys. Okay. So on here, this is saying any house that was built prior to 1978, there is a chance that lead is inside the paint, which there goes the name lead based paint addendum. Okay. The sellers are disclosing A or B, whether they know about there being a presence of the lead or they don't have any clue, or they have records of the lead and they know what's going on here, or there are no records because there is nothing that they know about. So they're clicking one of those. Based on that answer, the buyer is then saying, I waive the opportunity to conduct a risk assessment, or I want to conduct a risk assessment. And did I receive the pamphlet for the Protect Your Home from Lead in Your Family, which would be given by the buyer agent? Okay. And if they did receive copies of everything that the seller did disclose, and then everyone has to sign this. This is super important because people are dying or have died because of the lead in the paint, and people are inhaling it and all that kind of stuff, inhaling the air in the room and all that stuff with that paint in the walls. So that's why it's really big, and that's why we have to sign it. So that's big. That's a big time one. Now, your addendum regarding fixture lease, this document is going to be for Ring doorbells, security systems, water softener, propane tanks that are being leased out, solar panels, things like that. And what we need to know is if you have anything affixed to the property that also has a lease. If I'm buying that property from you, you need to disclose what's affixed to the property that's requiring a lease. Are you paying that lease completely off and removing that fixture from the property? Or are we keeping that fixture on the property and you are paying it off? Or am I assuming your responsibility financially for this lease and we're keeping the thing on the property? So if I want the solar panels, but I don't want to pay for them, then on A, we would hit solar panels. At closing, the seller shall assign to buyer to pay the solar panels off would not be the answer, because we don't want that. We want the seller to take care of these solar panel things, and we want the seller to leave them on the property. Okay. And then right here, just a delivery of all the information. Now, if the buyer is like, well, I'll take over the solar panel lease, you don't need to sell, you don't need to get rid of it, blah, 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 blah. So the seller does not own the solar panels, but at closing, the buyer will assume the solar panels and the seller will not take them off. Okay. And here's all the information regarding it. All right. So that's for your fixture leases. Okay, and now your residential lease. If you are listing a property or your client is purchasing a property where the actual owners do not live there, but they are renting the property, then you need the addendum regarding the residential lease there. And there's only two options here. Either I'm purchasing this property and they don't have to move out for another 6 months, and I'm going to take over. I'm going to assign the lease to the next person, and I now remove myself as landlord and I sell this property to the next buyer, who is now taking over the responsibility of being the new landlord. They cannot change the terms of the lease. They cannot take more money from them. They cannot make them get out. They have the right to stay in the house because they have a contract that's airtight. But if the person is going to buy your property before the lease is up, they will assume the residential lease. They will be the new landlord, meaning they will take on the utilities being paid by them. Renter's insurance needs to be going to them. The security deposit gets transferred to the new person, all of that. Or if they're like, I will buy the property, but I want to buy the property after the tenants have moved out. That means you're hitting the A, where the termination of the residential lease. You did what all you're saying is they finished their lease, but the lease has terminated and has not been renewed. And by the time I move in there, nobody is there but me. Okay. That's all this means here. Okay, environmental assessment, threatened, endangered, and wetlands. This is just a disclosure that just says the buyer has the right within X amount of days after the effective date of the contract, where they can go ahead and get whatever type of wildlife, environmental testing specialist, whatever, to come out to determine if that house is in some type of wetland or threatening an endangered species or anything like that. And if it comes back positive, then now the buyer can terminate within X amount of days and get their earnest money back. Okay. Okay, so we have three type of money addendums. If you remember, paragraph 3 talks about if you are going to, okay, sorry, technical difficulties. Sorry about this. Sorry. And it's recording. I apologize. Okay. All right, here we go. So on paragraph 3 in your 1 to 4 family contract, you only have 4 options as far as how someone is going to buy a house. Either it's going to be a loan assumption, a seller financing, third party financing, or it's cash. Okay. This is a loan assumption. What this means is somebody's terms are so favorable and it does qualify for loan assumption, meaning it's probably a VA or an FHA loan, that the buyer who's now coming to buy the property, they like your terms so much so that they're going to assume your loan responsibility. Okay, so remember that other document that we just went over releases the seller's responsibility. It releases them because they're no longer required to be obligated to this loan because someone else has assumed it. This is what pairs with that. Okay, so as the buyer, and let's just say it's a house from back like 4 or 5 years ago where interest rates were 2.75% compared to now they're like 6.75, right? It's a huge difference. So I want to assume a loan that has that 2.75 interest rate. The catch 22 behind that is there's an equity buildup. So what you're assuming is the exact loan terms. So if the house has a loan at 2.75 interest rate and the amount owed on the loan is only 300,000, but they're selling the house for 400,000, that means you have to come to the closing table with that extra 100,000 to assume the current loan status and the loan terms, okay? This document is just detailing what those terms are that you are assuming and agreeing to. Okay? And so I'm going to skip down the list a little bit because I want it to all make sense as we're talking. Now, what seller financing is a little bit different. Seller financing means that the seller is financing the home, meaning that the seller owns the property outright. So you cannot do seller financing if someone else has a loan out on that house. That means you don't own it outright. So I own this property, 123 Easy Street, completely outright. As a buyer, for whatever reason, you either don't want to or you cannot qualify through a bank to get traditional funding. So because I own this property outright, I have the right to give you seller financing. I will tell you what your down payment is directly to me. Basically, I am the bank as the seller. I am picking whatever interest rate I want. I do not have to go by standard terms of whatever the government is offering at that time. I can pick whatever interest rate I want because you can't get approved or don't want to get approved through the bank. You want to be approved by me as the seller. I get to determine the terms. Who's paying title, who's paying closing costs, all of that. I'm the bank. That's what seller financing is. The seller is the bank. They determine the terms, and whatever those terms are that everyone agrees to, you're putting them here in this document. Okay. Now, the third party financing addendum is the one that we know about all too well. It's doing it again. Here we go. I'm so sorry about this, guys. Okay. So the third party financing addendum is the one that we use all the time. That's going to be the addendum regarding conventional loan, FHA loan, VA loan, special financing, USDA loan, Texas Veterans Land Board, reverse mortgages, all of the other types of loans. Okay. So remember, we talked about earlier the right to terminate due to a lender's appraisal. And I said FHA and VA do not qualify to use that addendum. That's because right here on the second page, this paragraph 4, covers the right to terminate for them in the third party financing addendum. So you don't need a second addendum to talk about the same thing. Okay, so that's why they tell you not to use that addendum if they're using a VA or FHA loan because it's covered right here in this document. Okay, so what you're doing here is you're picking one of these loans. Okay, so if it's a conventional loan, you only fill out the conventional loan piece, which is right here, all of this, and then you leave the rest of it blank. You don't have to fill in anything else because you can only do one loan at a time, right? So this is going to be your third party financing, and that's it. This is the third party financing. Okay, all right. Okay, so now let's go back up a little bit. We only have Two, three more. Okay, so the non-realty addendum, this one's easy peasy. If you're wanting the seller to leave anything in the property for the buyer after closing, you would put that here. So if you want the seller to leave your washer, dryer, in the fridge, in the kitchen, you would put that here. And if that seller says, sure, I'll leave it for a certain amount of dollars, then that's what you're putting here. So if they tell you, well, for $500, I'll leave the washer, dryer, and the fridge. No problem. Or if it's the washer, dryer, and the mounted TV in the family room, no problem. You just put that information there and you put how much. Now, if it's zero, then you don't put zero. Just been told by lenders over the years that they don't like when this is zero, so I always just put one. So it's for $1 is what you're leaving the washer, dryer, and the mounted TV in the family room for. Okay. Okay, so now we have the seller's temporary lease. So, my gosh, why does this keep happening? So I skipped the buyer's temporary lease earlier because they're the same document. So I didn't go over the buyer's temporary lease because I knew I was going to do the seller's temporary lease at the end. Okay, so the seller's temporary lease, the buyer's temporary lease, and the seller's temporary lease are the exact same form. One is just for the buyer, one is for the seller. If it's a seller's temporary lease, that means for up to 90 days after closing, the seller can no longer can turn themselves from being the owner of this property to now being the tenant of the same property. Okay, so what that means is I've sold my property to Jane Doe, the buyer, but I need to live here an additional 2 weeks before I can move into a property that I'm buying in another state. So I can lease the property back from the person I just sold it to. I'm going to stay here after closing. I'm going to keep my key and all that stuff. And now I am a tenant and I'm going to pay rent to the new owner, which is the previous buyer. And then when my 2 weeks are up, I have to put in a security deposit. I get my security deposit back, all that. And then I move into my new place. The same thing for the buyer's temporary lease. If I have the right as a buyer, if we agree to it, that I can move into a property 90 up to 90 days prior to closing. So if I sell my house in Wisconsin 30 days before I'm closing on my house in Texas, I'm homeless for 30 days. Mr. and Mrs. Seller, that house is vacant. Can I go ahead and move in and I'll see you at closing in 30 days? And I'm going to rent it from you. That would be the lease. Okay. And then the very final document, let's see if this site will be nice to me, is the short sale document. Woohoo! Okay, this is the addendum regarding a short sale, meaning I'm going to sell my property for a lesser amount owed to the mortgage company. This could happen for someone that's about to face foreclosure, things like that, and they need to sell in a hurry. They need to sell to an investor. You can only do a short sale if the lender allows you to do a short sale. You have to get permission from them first because they own the loan. And technically, the way that deeds work, it is your house, but it's really the bank's house until it's been paid off. Okay, so you cannot do a short sale and sell a house for what's a lesser amount owed to that bank without getting permission. Okay. All right. That's all of the addendum, the TREC promulgated addendum that is on the TREC website. If you have any questions at all, just give me a holler and we can talk about it. Remember, if you need anything from me, you can either get to our website and look at another training video potentially, or just give me a shout. Thank you so much. And again, happy holidays.